All right, let's be on the record in case number 2020 CR 194, captioned State of Kansas versus Charles Kirsch. Would the parties announce their appearances?
State of Kansas appears fine through Assistant District Attorney Garrett Rell.
May it please the court, Charles Kirsch appears virtually by Zoom here in my office, his attorney, John Ivan.
All right, we were here sit down originally for a pretrial conference, but my understanding is the parties have reached a plea agreement. And today, Mr. Kirsch is intending to plead no contest to the amended charge of domestic battery, a Class B misdemeanor. Mr. Rell, do I have that correct?
Yes, Judge.
And Mr. Ivan?
Yes, Your Honor.
All right, Mr. Kirsch, let me just ask you some questions about this that I need to know before I can accept this plea. Now, if I ask you something that you don't understand, I want you to tell me that, okay?
Yes, Your Honor.
All right. And if you want to talk to Mr. Ivan in private before you answer a question, you just tell me. He can mute your microphone. You guys can talk and then come back when you're done, okay?
Yes, Your Honor.
All right. Mr. Kirsch, how far did you go in school?
I did a high school diploma online.
All right. You read and write English, okay?
I'm okay with most of
All
it.
right.
Yes.
So did you and Mr. Ivan go over a plea petition in this case?
Yes, Your Honor.
Were you able to read it, or was Mr. Ivan able to explain anything you didn't understand?
Mr. Ivan explained to me what I didn't understand, Your Honor.
Okay. Now, do you know what you're charged with?
Yes, Your Honor.
And you know that you don't have to change your plea from not guilty to no contest. If you wanted to maintain your not guilty plea, you would have a right to a jury trial on those charges. You understand that?
Yes, Your Honor.
All right. At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Ivan would assist you throughout that trial. He could cross-examine and confront all of the state's witnesses, call anybody you wanted to testify. You could take the stand, or you could decline to testify. And if you decided not to testify, the state couldn't use that against you. In other words, they couldn't get up and argue, well, you should find Mr. Kirsch guilty because he didn't tell you his side. You understand all that?
Yes, Your Honor.
If we had that trial and at the end of the trial you were convicted, you would be able to appeal that conviction to the Kansas appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. You understand that?
Yes, Your Honor.
All right. Now, if I accept this plea today, you're going to be giving up all those rights. There's not going to be a trial of any kind. You understand that?
Yes, Your Honor.
Before we came on the record, the parties told me that the recommendations for sentencing today were going to be that I give you a 6-month underlying jail sentence and 12 months of probation, in which you'll have to get a domestic violence assessment and follow the recommendations. And that if you complete everything timely, the state understands you may file a motion to try and have early termination of that probation. Is that your understanding of the entire plea agreement?
Yes, Your Honor.
All right. Has anybody else promised you anything to get, other than what I just said, to get you to plead no contest today?
No, Your Honor.
Anybody placed any force or threats against you to make you plead no contest today?
No, Your Honor.
Now, on those sentencing recommendations, I'm going to listen very closely to those, and I usually follow the recommendations, but I'm not bound by them, and I'm not party to them. So I can give you any sentence that the law allows me to give you. Do you understand that?
Yes, Your Honor.
All right. Now, the maximums for these crime is 6 months in jail and a fine of $1,000. You understand that those are the maximums?
Yes, Your Honor.
All right. Do you have any questions for me or Mr. Ivan about anything that you and I have talked about today?
No, Your Honor.
All right. Knowing all this, do you still want to enter your plea of no contest?
Yes, Your Honor.
Mr. Ivan, do you know any legal reason why your client should not plead no contest today?
No, Your Honor.
All right. Then I'm going to ask you, Mr. Kirsch, as to the amended information charging you with 1 count of domestic battery, a Class B person misdemeanor, how do you plead? Guilty, not guilty, or no contest?
No contest.
No contest.
All right, thank you. I'm gonna ask the state to tell me what they think the evidence they would be able to put on if this went to trial is. I want you to listen closely. I'm not gonna ask you if you agree or disagree, because by pleading no contest, you're not admitting any of this. But I want to make sure that you understand that this is the evidence the state believes they could put on, okay?
Yes, Your Honor.
Mr. Ralph,
Yes, Judge. The state would present evidence at trial that on February 16th, 2020, officers were dispatched to 1804 North 76th Street, apartment number 10, here in Kansas City, Kansas, Wyandotte County, for a domestic disturbance. There, they met two individuals, one Sidney McLaughlin and the other Charles Kirsch. The two had been in a dating relationship for about 8 to 9 months and had been living together for 4 months. They got into a verbal argument, which then became physical. The physical argument was, or the physical altercation was initiated by Mr. Kirsch and was not done with the permission of Miss McLaughlin.
all right. Mr. Kirsch, you heard what the state had to say. Do you understand that if you went to trial, that's what they believe they could put on for evidence?
Yes, Your Honor.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently changed his plea from one of not guilty to one of no contest. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and the defendant has chosen not to contest that factual basis. Therefore, I will find he is in fact guilty of the amended charge of domestic battery, a Class B misdemeanor. My understanding is the parties wish to waive pre-sentence investigation and proceed to sentencing at this time. Is that correct, Mr. Ralph?
Sorry, Judge. Yes, that is correct.
And Mr. Ivan?
Yes, Your Honor.
All right. Then, Mr. Ralph, I'd hear any comments if you have any as to sentencing today.
Judge, the plea offer that I sent to the defense was that we asked for 6 months underlying, 12 months probation with court services. We asked that a domestic violence assessment be done, and that the defendant follow any recommendations that as a result of that evaluation. Standard court costs and fees. I would ask for no contact with the victim in the case. The defense had asked if he could apply for early termination once all conditions of the probation were met, and the state is agreeable to that. So I would ask that you follow those recommendations.
Thank you. All right. Mr. Ivan, your comments as to sentencing?
Thank you, Your Honor. First of all, since this incident occurred, my client has not been involved, charged, or involved with any type of new activity that would be considered a crime. I think he has in his past one non-person misdemeanor, which is more than 10 years old. He currently works, he's part of the union, and he works 10 and 12-hour days in asphalt. Extremely hard work. The season is just beginning, and he's noted to be a hard worker. He's got strong support from his family. He's just genuinely a good person. The relationship that was involved with this particular situation had become a volatile situation. It actually had been terminated prior to this incident, and part of the argument was over whether it should have been terminated by Mr. Kirsch. And I think that it's a situation which he accepts responsibility. I know that he's been remorseful that he's had to bring himself and impose on the court because of this unfortunate situation and some of the judgments that were spontaneously made at the time. I believe that he will be very successful if the court offers him a contract of probation. He's had no prior domestic related incidents or charges. He is not known as, even though he's a strong person, he characterizes himself as a gentle giant. He's not a person that has a volatile anger problem or a controlling problem. His family has entreated me time and time again, and probably that's the reason this case had advanced this far, partly because of the pandemic, but partly because some of the more serious allegations that were included in some of the reports were strongly disputed. But he does accept responsibility for the issue that, or the charge that he has issued no contest. The no contest plea does not indicate he's not accepting responsibility. It only indicates that we didn't know what the rendition of facts might be from the state, and some of the facts that led to the original charges were disputed. So with that said, we would ask that you accept the plea offer. The early termination issue is partly because of the 6 day a week, 12-hour days that he works in the asphalt business, and we could anticipate that in this particular season that might the probation might, if it extended for the whole year, might be problematic with his work, but whatever's required, he's going to do. And with that, we would ask the court to accept the plea offer and agreement that's been reached with the state.
Thank you, Mr. Ivan. I'm curious. So this is a relationship that is over. There's no reason, sometimes I do no violent contact instead of no contact, but these parties don't wish to have any contact with each other. Is that correct?
That's correct, Your Honor. There's been no contact whatsoever. The only information that we have ever even received was at the preliminary hearing. And occasionally a friend will say, we heard something about such and such. Other than that, there's been no issue of stalking or contact or any continuous relationship whatsoever.
Okay, thank you. Mr. Kirsch, if you wish, now is your opportunity to tell me anything you want me to know in mitigation of your sentence.
No, Your Honor.
All right. Well, I'm going to follow a plea agreement. I think this is a well negotiated case, and I think it's a just outcome. So I am going to follow the plea agreement. I will sentence Mr. Kirsch to 6 months in county jail. That time will be suspended, and he will be placed on probation for a period of 12 months with adult court services here in Wyandotte County. A specific term of that is that he have no contact with the victim in this case, and that he complete a domestic violence assessment, follow any recommendations that it may contain. Court costs and misdemeanor court costs and misdemeanor supervision fees are assessed. Attorney is retained, so there's nothing there. There's no request for restitution, so it'll simply be that. Here's what I'm going to do, Mr. Kirsch. I'm going to order that you pay $50 a month towards that. That's a minimum payment. Obviously, if you're trying to get off early, you'll want to get that paid off faster than that. But that it would be a minimum of $50. Is that something you'll be able to make?
Yes, Your Honor.
Okay. All right. Okay. I think that takes care of it. I'm going to go off the record before I tell Mr. Kirsch how to report. Is there anything else that we need on the record that you're aware of, Mr. Ralph?
No, Judge.
Mr. Ivan?
No, Your Honor.